Maplewood, Georgia. Superior Court, Chandler County. A Thursday morning in March, overcast and cold in the way that early spring in the South can be, the kind of cold that arrives without the excuse of winter, that has no business being there and stays anyway. The date stamp on the courtroom camera read like the first word of a sentence no one in that room wanted to finish. Cora Lane Whitfield, 14 years old, entered through the side door of courtroom 7 flanked by 2 court officers and her attorney, and the first thing everyone noticed was her hair. It had been brushed, carefully with the kind of attention that takes time, pulled back on one side with a small clip that caught the courtroom light, the kind of clip that a girl of 14 wears to school on a picture day or a class presentation. It was not an accident. Nothing about Cora Whitfield's appearance in that courtroom on that morning or any morning that followed was an accident. She wore a pale blue blouse beneath a dark cardigan, both selected by her mother, who had driven to the juvenile detention center the previous evening with a garment bag, and the specific, desperate hope of a parent who believes that if their child looks young enough and soft enough and small enough, the room will be merciful. Cora looked young. She was young, 14 years old, slight, with large gray eyes and the kind of face that adults describe as sweet, the face of a child, plainly and unmistakably, in the way that makes what happened more difficult to process rather than less. She walked to the defense table and sat down beside her attorney, Patricia Vance, a criminal defense lawyer from the county's public defender's office, who had spent 16 years navigating the particular territory between what the law permits and what it can bring itself to do to a child. Vance had worked hard cases before. She had not worked a case like this. Cora settled into her seat, folded her hands on the table, and looked at the courtroom with the expression of someone taking careful inventory. Not anxious, not remorseful, not performing distress in the way of a teenager who understands that distress is what is expected. She looked at the bench, at the prosecution's table, at the gallery packed with parents and journalists, and the families of children who had attended the same school as Cora Whitfield and Aubrey Nolan. She looked at all of it with the measured, assessing attention of someone who is gathering information and deciding what to do with it. She did not look at the family seated in the first row of the gallery on the right side of the room. She looked everywhere else, deliberately, systematically, like a person examining a room for exits, and she did not look at the family of the girl she had killed. That choice would be noted by every person present. In the first row, Diane Nolan sat with her hands pressed flat against her thighs and her eyes fixed on the front of the room. She was 42 years old, a dental hygienist who had worked the same practice in Maplewood for 11 years, and was known by the families in the neighborhood as a woman who remembered details, the names of children's pets, the dates of school events, the specific allergies of every child who came through her daughter's rotating roster of friends. She had spent her daughter's whole life paying attention. Now she paid attention to the girl at the defense table, to the careful hair, the pale blouse, the folded hands, the eyes that went everywhere except toward the family they had destroyed. Diane Nolan had not slept more than 3 hours in a row since November 14th. She had not opened the door to Aubrey's room since November 15th. She had not yet been able to say her daughter's name out loud in conversation without something happening to her voice that she could not control. She sat in the first row of courtroom 7 and paid attention. The judge entered. Everyone rose. Judge Sandra Elwood was 57 years old, a graduate of Emory Law with 22 years on the Georgia Superior Court bench, the last 9 in Chandler County. She had presided over more criminal cases than she could accurately count, including 3 involving juvenile defendants charged as adults. She was known in the county legal community for 2 things: a patience that was genuine rather than performed, and a clarity that arrived, when the moment required it, with the force of something that had been building for a very long time. She took the bench, surveyed the courtroom with the quiet authority of someone who has done this long enough to read the room before anyone has spoken, and called the case. "The state of Georgia versus Cora Lane Whitfield," she said. Her voice was measured and clear and left no space for ambiguity. "The defendant is present. Counsel is present. Let's proceed." Assistant District Attorney James Ritter rose. He was 44, broad-shouldered, with the unhurried manner of a career prosecutor. O had learned long ago that the most powerful thing in a courtroom is not volume or theatrics, but the careful, relentless laying of fact upon fact, until the structure they form is undeniable. He had a file folder in front of him that he had read so many times the edges were beginning to soften. "Your Honor, the state charges Cora Lane Whitfield, age 14, with murder in the first degree in the death of Aubrey Me Nolan, age 14, a student at Maplewood Middle School in Chandler County. The victim died on the afternoon of November 14th from asphyxiation caused by manual strangulation. The state contends this was a premeditated act, planned and carried out with deliberate intent, and that the evidence supports the charge as filed against the defendant as an adult under the Juvenile Justice Reform Act." Patricia Vance rose. "The defense maintains that the state has made a profound and consequential error in charging a 14-year-old child as an adult in this proceeding. Cora Whitfield is a minor. Whatever the state contends occurred on November 14th, the law and the science of adolescent development demand that this case be adjudicated in juvenile court, where the focus is rehabilitation rather than punishment. We will vigorously challenge both the charge and the transfer to adult court." Judge Elwood looked at Cora. "Ms. Whitfield, do you understand the charges against you as they have been stated?" Cora looked at the judge. "Yes, Your Honor," she said. Her voice was clear, composed, the voice of a girl who had practiced this, who had understood from the moment she entered this building that every word she spoke would be measured and evaluated and remembered. "And how do you plead?" "Not guilty." 2 words, no hesitation, no visible distress, the flat, clean assertion of someone who has made their position and intends to hold it. Judge Elwood looked at Cora for a moment longer than necessary, not with hostility, with the specific, careful attention of someone assembling an impression they intend to return to. Then she turned to the matter of detention, ruled that Cora would remain in the juvenile facility pending trial, and scheduled the next proceeding. As the court officers rose to escort Cora from the room, she turned and looked, for the first and only time that morning, at the gallery. Not at her mother, who was seated 4 rows back with her hands clasped so tightly her knuckles had gone pale. At the cameras. She found them in under 2 seconds. The print journalist in the 3rd row. The video camera from the local news affiliate positioned near the back wall. She found them and looked at them with the particular directness of someone who has thought about being observed and is ready for it. Then she turned and walked through the side door. The room let out a collective breath it had not known it was holding. Before we go further into what investigators found and what this case revealed about the weeks leading up to November 14th, if you found this story, please take a moment to subscribe so you never miss an episode. And drop a comment letting us know where you're watching from. These cases matter because the people in them matter, and your engagement helps make sure these stories are heard. Now let's go back to Maplewood, Georgia, where a 14-year-old girl was sitting in a juvenile facility with her hands folded in her lap, and where a detective named Maya Acaffer was just beginning to understand the full shape of what she was dealing with. Aubrey Me Nolan had been 14 years old and had been, in the specific, irreplaceable way of a person, just beginning to understand who they were going to become, extraordinary. She had been the kind of student who raised her hand not because she was performing eagerness, but because she was genuinely, irrepressibly curious about things. She had been reading novels since the 2nd grade. She had won the Chandler County Middle School creative writing competition 2 years in a row, submitting a short story in 7th grade about a lighthouse keeper's daughter that the judges described in their notes as unusually observed for a child her age. She had been learning to play the guitar, badly, enthusiastically, with the specific joy of someone who does not yet know they are supposed to be embarrassed by imperfection. She had been the kind of friend who remembered what you told her 3 weeks later and asked about it. The kind who texted you after a hard day without being prompted. The kind who, according to her best friend since the 3rd grade, would notice when you had changed your hair before you had finished walking through the door. She had been found at 5:43 in the afternoon of November 14th in the maintenance access corridor behind the drama building at Maplewood Middle School, a narrow passage between the building's exterior wall and the campus perimeter fence, accessible through a door that most students did not know existed. She was found by a custodial worker named Jean Bartholomew, who had been taking the access corridor as a shortcut to the equipment shed, and who had been a custodian at Maplewood Middle for 11 years, and had never, in those 11 years, been asked to describe what he had seen in that corridor. He would spend the rest of his life wishing he had not seen it. Aubrey Me Nolan had been strangled, manually. The medical examiner's preliminary finding, delivered within hours of her discovery, established asphyxiation as the cause of death. The bruising on her neck was consistent with hands, consistent with sustained, deliberate pressure. Not a moment of panic or impulse, but an act that had required sustained effort and sustained decision-making across an interval of time that the ME estimated at 4 to 6 minutes. 4 to 6 minutes is a very long time. That fact, more than any other single fact in the case, was the one that Detective Maya Acaffer carried with her from the moment she read the preliminary report. She was a 15-year veteran of the Chandler County Sheriff's Office Criminal Investigation Division, a woman who had spent those 15 years developing the specific skill of looking at what happened and working backward to find why. She had worked violent cases and quiet cases and cases that seemed one thing and turned out to be entirely another. She had a rule about assumptions that she had formulated early in her career and had never violated. Do not decide what you are looking at until the evidence tells you. She arrived at the school at 6:15 that evening. The corridor had been secured. Scene technicians were working the narrow passage with the methodical care of people who understand that the space they are in is small and the evidence it contains is everything. Acaffer stood at the entrance to the corridor for a long time, looking. The corridor was 7 feet wide. The perimeter fence was chain link with a strip of privacy screening woven through it. The door from the drama building opened inward and had no exterior handle. It could be opened from inside but not from outside. Anyone using it needed to know it was there and needed to access it from within the building. This was not a random location. Someone had brought Aubrey here, or someone had asked Aubrey to come here, and Aubrey had come. That was the first question, and in the answer to that question, Acaffer already suspected, was the answer to most of the others. The canvass of the school community in the hours following the discovery produced the first strand of the thread Acaffer had been looking for. Students who had been in the drama building that afternoon, which was most of the drama club, 23 students in total, gathered for a rehearsal of the winter production, had been interviewed by the initial responding officers. Among those interviewed was a girl named Cora Whitfield, who had been in the building until approximately 4:15 before heading home, and who had, according to her own account, not seen Aubrey that afternoon. This was, on its face, unremarkable. What was less unremarkable was the answer to the question Acaffer asked on day 2 of the investigation. What was the relationship between Cora Whitfield and Aubrey Nolan? The question produced, in the way that questions about social dynamics in middle school communities always produce, a complicated and revealing answer. Cora and Aubrey had been in the same social circle since 6th grade. They had not been best friends. Aubrey's best friend was a girl named Priya Rao, but they had been close enough to share lunch tables, to text regularly, to be present at the same birthday parties and weekend gatherings. From the outside and from Cora's own account, they were friends. From inside the drama club, the picture was different. 3 members of the drama club, interviewed separately, described a dynamic that had shifted in September, 2 months before Aubrey's death. The winter production, a condensed adaptation of a classic play that the drama teacher, Mr. Ellison, had arranged to allow for a cast of the club's full membership, had a single principal role available, a female lead. The auditions had been held in the second week of September. Aubrey Nolan had gotten the part. Cora Whitfield had also auditioned. Mr. Ellison, when interviewed, described the decision as not a difficult one from a technical standpoint. Aubrey had considerable natural talent, a stage presence unusual for her age, and the role required a specific emotional range that she was capable of accessing. Cora was competent. She was a capable member of the ensemble, but the decision had been clear. He had not anticipated the aftermath. 3 club members described, independently and without coordination, the same shift in Cora's behavior following the casting announcement. She had not been visibly angry, not in the way that would have been noticed and addressed by an adult. She had been in the word that all 3 students reached for without knowing the others had used the same word, quiet, quieter than before, the kind of quiet that is not peace but is its deliberate performance. She had continued to attend rehearsals. She had continued to show up and run her ensemble lines and sit in the rehearsal space and watch Aubrey deliver the lead scenes from the second row of chairs. And she had watched, according to one of the 3 students, a girl named Jade, who had been close enough to Cora to notice details, with an expression that Jade had found unsettling enough to mention to her own mother when she came home from rehearsals. Not rage, not sadness. Something Jade described, at 13 years old, with the specific precision that children sometimes achieve about the things they observe in their peer group, as decided. Like she had already made up her mind about something, Jade told Detective Akafer in a conference room at the school with her mother present, and she was just waiting. This was the thread. Akafer pulled it. The warrant for Cora Whitfield's phone was obtained on day 4 of the investigation. It was executed on day 5. The phone, a model that had been a birthday gift the previous summer, was submitted to the state's digital forensic lab in Atlanta, where a technician named Bernard Soley spent 3 days working through its contents. What he found in the phone's deleted file partition would become the centerpiece of the state's case. Cora had deleted a series of text messages in the 48 hours following Aubrey's death. This was not unusual. People delete messages routinely, for reasons that have nothing to do with criminal activity. What was unusual was the specificity of what she had deleted and what the forensic recovery process was able to reconstruct. The messages were a conversation between Cora and Aubrey's phone, initiated by Cora on the afternoon of November 14th, beginning at 3:52 p.m. Cora, hey, are you still at school? Aubrey, yeah, in the drama building, why? Cora, can you come out back real quick? I need to show you something, it's about the show. Aubrey, like the corridor. Cora, yeah, the back door is open, I propped it. Aubrey, okay, give me 2 minutes. The messages had been deleted from Cora's phone at 6:02 p.m. on November 14th, 14 minutes after Jean Bartholomew found Aubrey's body and called 911, before the first officer arrived, before the school was secured, before anyone could have told Cora that the investigation was going to include her phone. She had deleted them within 12 minutes of Aubrey being found. She had been watching. The second item Bernard Soley's recovered from the deleted partition was not a text message. It was a voice memo, 47 seconds long, recorded on November 11th, 3 days before Aubrey's death. It had been saved in the phone's default voice memo application under a file name Cora had apparently assigned without giving much thought to how it might appear to someone else. The file name was After. Solis played it twice in the lab before he called Akafar. When Akafar listened to it, she sat very still for a long time after it ended. The recording was Cora's voice. Quiet, measured, the same controlled tone she would use in the courtroom months later. In it, she described in the flat, matter-of-fact language of someone working through a logistics problem what she intended to do on November 14th. She described the corridor. She described the timing after rehearsal when the building had cleared out. She described the message she intended to send to lure Aubrey there. She described what she intended to do when Aubrey arrived. Not in graphic terms. In terms that were, in their own way, more disturbing than graphic language would have been. In the clinical, organized terms of someone who had thought about this carefully and was reviewing their plan the way a student reviews notes before an exam. At the end of the recording, before she stopped it, she said, "She doesn't deserve what she has." 47 seconds. 3 days before Aubrey Nolan was killed, Akafar submitted the recording as evidence and obtained a warrant for Cora Whitfield's arrest on the 9th day of the investigation. Cora was arrested at the juvenile detention intake facility, where she had been placed following a preliminary interview with Akafar on day 6, an interview in which she had answered every question calmly, thoroughly, and with the particular precision of someone who has prepared for a test and is confident in their answers. She had maintained, without wavering for a single moment, that she had not seen Aubrey on November 14th, that she had left the drama building at 4:15 and gone home, that she and Aubrey were friends, and she was heartbroken about what had happened. She had said all of this without fidgeting, without looking away at the wrong moments, without any of the nervous physical signals investigators learned to read in the early hours of a case. When Akafar informed her of the arrest, Cora looked at her for a long moment. Then she said, "Can my mom come?" It was the most ordinary thing she had said since the investigation began. It was also, Akafar would reflect later, the last ordinary thing. The arraignment drew a courtroom more crowded than the one that had housed the initial appearance. Word had moved through Maplewood in the specific way that devastating news moves through small communities. Not as rumor, not with the distortions that rumor introduces, but as a kind of collective shock that traveled from household to household and left behind it a kind of silence that the community did not know how to fill. Parents who had sat next to Diane Nolan at school concerts. Teachers who had graded Aubrey's essays and kept them. Students who had shared lunch tables with both girls and could not make the two facts, Aubrey dead, Cora charged, exist in the same mental space. The hearing to transfer Cora's case to adult court was heard over 2 days and generated a legal filing from Vance that was thorough, carefully researched, and argued with genuine conviction. She cited the neuroscience of adolescent brain development, the research on juvenile rehabilitation outcomes, and the specific provisions of Georgia law that govern the transfer standard. She called an expert witness who testified for 90 minutes about the incomplete development of the prefrontal cortex in 14-year-olds and what that development implied about culpability and moral reasoning. Ritter countered with the voice memo. 47 seconds. Recorded 3 days in advance. Describing a corridor, a message, a timing, an outcome, all in the language of organized, deliberate forethought. Not the language of a brain that could not assess consequences. The language of a brain that had assessed them thoroughly and proceeded anyway. Judge Elwood granted the transfer. She did not take long to decide. The trial began on the second Tuesday of March, 6 months after Aubrey Nolan's death, and by that point Maplewood had done what communities do in the long space between a crime and its reckoning. It had found ways to hold the grief and continue. A memorial garden had been planted outside the drama building, maintained by the drama club members who continued to rehearse inside. sometimes stopping to look out the window at the small plants that Aubrey's mother had chosen. The winter production had been canceled. The spring production had been quietly planned and then quietly canceled as well, because no one could figure out how to rehearse in that building and pretend that the absence wasn't the loudest thing in the room. Cora Whitfield entered the trial courtroom on the first day with the same careful presentation she had brought to every preceding appearance. The hair was brushed. The clothes were appropriate. The expression was, on the surface, composed and cooperative. What it was beneath the surface, what it had always been beneath the surface, from the first day in the arraignment courtroom to this one, was something that the people who watched her carefully had increasingly settled on a single word to describe. Calculating. Not the calculation of cruelty, not exactly. The calculation of a person who understands that they are being evaluated and is managing the evaluation in real time, adjusting for what each audience in each moment seems to need from her. Around her attorney, she was cooperative and attentive. Around her mother, she was subdued and occasionally tearful. In front of the judge and cameras, she was composed. In the brief moments when none of those specific audiences were watching, her face settled into something else, the expression she wore when she thought she was alone, the expression that was not composed or cooperative or tearful. Jade had described it as decided. That was still the most accurate word. Ritter's opening statement was methodical and built like architecture. He walked the jury through the nature of the crime, the location, the timing, the manner of death, the 46-minute window that the medical examiner had established. He introduced the jury to Aubrey Nolan not as a victim, but as a person, the Creative Writing Awards, the Lighthouse Story, the guitar practiced badly and joyfully in a bedroom down the hall from where her mother was cooking dinner. He spent time on Aubrey as a person because he believed, and had believed in every case he had prosecuted, that the jury needed to understand what had been taken before they could fully understand the taking. Then he introduced the evidence. The text messages, reconstructed by forensic recovery, each one timestamped and attributed, tracing the last 12 minutes of a conversation between two phones whose owners had been described as friends. The message from Cora at 3:52 p.m. The response, the confirmatio. In the corridor, the propped door. He watched the jury as they absorbed this, reading their faces with the practiced attention of a career prosecutor. He saw the moment when the word came to them. The word was bait. Then he played the voice memo. 47 seconds. The courtroom was completely silent while it played. No movement, no papers shuffling, no ambient noise of the kind that normally underlies the quiet of a packed room. Just Cora's voice from a speaker mounted near the evidence table, measured and clear and describing what she was going to do on November 14th, 3 days before November 14th arrived. She doesn't deserve what she has. When the recording ended, the silence persisted for several seconds. Cora Whitfield sat at the defense table with her hands folded and her expression unchanged. That absence of reaction, the fact that she heard her own voice describing the plan she had carried out and showed nothing visible at all, was the thing that 3 jurors would independently cite in post-verdict interviews as the moment they understood what kind of case they were in. Vance's opening was everything a skilled defense attorney could do with the hand she had been dealt. She argued that the recording was ambiguous, that the words of a 14-year-old expressing dark feelings did not constitute a criminal plan. She argued that the text messages proved only that Cora had asked Aubrey to meet her, not what had happened when they met. She argued that the physical evidence at the scene was incomplete, that no DNA directly linking Cora to the act of strangulation had been recovered from an identifiable source. This last point was technically accurate. The physical evidence at the scene was circumstantial in the narrow forensic sense. The coroner had provided limited trace evidence. No fingerprints on Aubrey's neck, No skin cells under her fingernails recovered from a source that could be conclusively attributed. Ritter had anticipated this. He had built his case so that the physical evidence was the frame, and the voice memo and the text messages were the painting inside it. The first 4 days of testimony moved through the investigation's foundation, Akaffer walking the jury through the timeline, the forensic technician presenting the recovered data with the patient, technical precision of someone who has explained digital forensic recovery to a jury before and understands what they need to understand. The medical examiner, a woman named Dr. Claire Pang, delivered the most difficult testimony of the first week. The manner of death, the duration, the specifics of what manual strangulation means and what it requires of the person doing it. She described what 4 to 6 minutes feels like in real time. Several jurors looked away. Cora did not. On the 5th day of trial, Ritter called a witness whose inclusion had generated a legal battle that Judge Elwood had resolved 4 weeks before trial began. The battle had been fought over the admissibility of the testimony, over the question of whether what the witness had to offer was hearsay or direct evidence, over the specific weight a court should give to a conversation recalled months after it occurred. Elwood had ruled the testimony admissible. Ritter called Mara Whitfield, Cora's older sister. Mara was 19 years old, a first-year student at a college 2 hours from Maplewood, and she entered the witness stand with the expression of someone who has been carrying something for months and has reached the point where the carrying has become more costly than the putting down. She was tall in a way Cora was not, with the same gray eyes, and she walked to the stand with the particular deliberateness of someone placing their feet carefully on uncertain ground. She and Cora had always been close in the particular, complicated way of sisters separated by 5 years. Mara old enough to be something between a peer and an authority figure, Cora young enough to want both things from her at once. They had talked regularly by phone since Mara left for college in August. They had talked. Mara had told Detective Akaffer in the conversation that had led to her being added to the witness list about many things, including one conversation in late October that Mara had not been able to stop thinking about since November 14th. Ritter approached the witness stand with the measured gentleness of a prosecutor who understands that the witness in front of him is being asked to do something that will cost her in ways the courtroom cannot fully account for, and who intends to ask it anyway because the alternative is a girl in a corridor and a mother who cannot open a bedroom door. Ms. Whitfield, can you describe the nature of your relationship with your sister prior to November of last year? We were close, Mara said. Her voice was steady, low. We talked almost every day, text, phone calls. She told me things she didn't tell other people. That was the dynamic between us. And in October of last year, did she tell you something about a classmate named Aubrey Nolan? Mara looked at her hands briefly, then at the jury. Yes. Can you describe that conversation for the court? Mara took a breath. It was a phone call. The 3rd week of October, I think, maybe a Wednesday evening. Cora called me and she was talking about the drama club, the auditions, about not getting the lead role. She paused. That wasn't unusual. She called me a lot when things bothered her. I was used to being the person she processed things with. I let her talk. And what did she say about Aubrey? She said Aubrey didn't deserve the part, that Aubrey thought she was special and she wasn't, that people kept giving Aubrey things that should have gone to someone who actually worked for them. Mara stopped. I said something like, that's just how auditions go, you can't win every time. And she got quiet, the kind of quiet that meant she was done explaining herself and had moved to a different place internally. And then she said she had been thinking about what it would be like if Aubrey just wasn't there anymore, if she was just gone. And she said it the way you say something you've thought about many times, not casually, not the way you'd say, I wish I could skip school today. Like she had considered it from multiple angles and arrived somewhere. The courtroom was completely still. "And what did you say in response?" I told her that was a dark thought and she needed to let it go, that she was upset about the audition and it would pass, that everyone had thoughts like that when they were angry and the point was not to hold on to them. Mara's voice had thinned. She said, "Maybe." And then she asked me how my classes were going and we talked about other things for 20 minutes. Did you take that conversation as a serious statement of intent at the time? No, the word came out like an admission rather than an answer. I didn't. I thought it was venting. I thought she was 14 and angry and saying something she didn't mean to someone she trusted enough to say it to. She looked at the jury. I have thought about that decision every day since November 14th, whether I should have called my parents that night, whether if I had said something to someone, anyone, whether it would have changed what happened. I don't know the answer to that. I don't think I'll ever know the answer. Vance's cross-examination was careful and precise. She established that the conversation Mara described was vague and nonspecific, that thinking about someone not being there was not a threat, that troubled teenagers express dark thoughts that do not predict violent action, and that any mental health professional would confirm that the expression of a dark thought in a moment of anger is categorically different from planning. Mara agreed to the technical accuracy of each of these points. She agreed to them with the specific flatness of someone agreeing to things that are true, but do not tell the whole truth. When Vance was finished and Mara stepped down from the witness stand, she walked past the defense table without looking at her sister. Cora watched her go. Her expression, in the moment when Mara passed, in the 3 seconds when she watched her older sister walk away, was the only moment in the trial when the calculation in Cora's face gave way to something unmanaged. It was not remorse. It was the specific, cold expression of someone who has been betrayed by the person they did not expect to be betrayed by. The expression of someone who believed a door was locked and has just watched it open from the other side. It lasted 3 seconds. Then the composure returned. And the jury had seen it. Patricia Vance put Cora on the stand on the 7th day of trial. This decision had been debated extensively between attorney and client, and Cora had ultimately insisted on it, had been, according to Vance in a post-trial interview, immovable. She wanted to testify. She was confident in her ability to perform on the stand. She believed that if she could look the jury in the eye and deliver her version of events, the version would be compelling enough to create reasonable doubt. Vance had agreed because she understood that sometimes a client is going to do what they are going to do, and the attorney's job then becomes making sure it does as little damage as possible. Cora took the stand with the same composed ease she had carried into every courtroom appearance. She answered Vance's questions with the open, prepared manner of a young person who has rehearsed carefully. She described her relationship with Aubrey as a genuine friendship. She described the day of November 14th as ordinary. She described leaving the drama building at 4:15 and going home. She said she had not seen Aubrey that afternoon. She said she had been devastated to learn what had happened. She said these things without looking away, without visible nervousness, without any of the physiological markers of deception that jurors are told not to rely on, and that they always, inevitably, factor in. She was very good. Ritter's cross-examination was not about attacking her composure. He had anticipated the composure. He had prepared for the composure. He had built his entire trial strategy around the understanding that Cora Whitfield was going to be composed and that the evidence was going to have to speak louder than she did. He asked her to explain the voice memo. Cora's explanation was that it had been a creative writing exercise, that she had recorded herself working through the plot of a story she had been developing, that the she in the recording referred to a fictional character, not to Aubrey Nolan, that the recording, taken out of context, sounded worse than it was. Ritter asked her to explain the text messages, specifically the word prompt, the phrase about the show. The specific operational detail of a door that most students didn't know existed, described in the precise language of someone telling a specific person how to access a specific location. Cora explained that she had wanted to talk to Aubrey privately about the production, that the corridor was quiet, that she had meant the conversation to be about blocking for a scene they were rehearsing. Ritter asked her why, if this was the case, she had deleted the text messages 14 minutes after Aubrey's body was found. The courtroom held its breath. Cora said she didn't know, that she had been upset, that she sometimes deleted messages when she was emotional and not thinking clearly. Ritter looked at her for a long, deliberate moment. "Ms. Whitfield," he said, "when you recorded that voice memo on November 11th, when you described a location, a message you intended to send, a timing, and what you intended to do in that corridor, were you describing fiction? Or were you describing what you planned to do on November 14th? Cora looked at him. For a long moment she said nothing. Then she said, "I was describing fiction." The jury foreman would later say that it was not the answer itself that had mattered. It was the pause before it. The specific quality of a pause that belongs not to someone searching for the truth, but to someone selecting between available options. The jury deliberated for 11 hours across 2 days. They returned a verdict of guilty on the charge of murder in the first degree. The foreperson read the verdict in a voice that was steady and clear, and when the last word landed, the silence that followed it was the particular silence of a verdict that everyone in the room had already arrived at individually and was now hearing confirmed aloud. Cora Whitfield did not react visibly when the verdict was read. She sat with her hands flat on the defense table and looked at the space between them. Patricia Vance placed a hand briefly on her shoulder. In the gallery, her mother made a sound that was not a word and pressed her hands over her mouth. In the first row on the right side of the room, Diane Nolan sat with her eyes closed and her hands folded in her lap and breathed slowly for a very long time. The sentencing hearing was held 3 weeks later. The courtroom on that morning had the quality of proceedings that no one present wanted to attend, and everyone present understood they needed to. The weight of a door that is about to close and will not be reopened. Diane Nolan spoke first. She had been preparing for this in the way you prepare for things that cannot truly be prepared for, by thinking about Aubrey, by deciding what Aubrey would have wanted said, by choosing words that were honest rather than performed. She stood at the podium and held a piece of paper she did not look at, and a photograph she held face down at her side until she was ready. Aubrey loved language, she said. She believed that words were the most important thing people had, that if you chose them carefully enough, you could say exactly what was true. She would have been mortified by the idea that I'm standing here trying to find words for what has happened to our family, because she would have said that some things don't have words. That language has edges, and beyond the edges there are things you can only feel. She stopped. I have been trying to find the words for what Cora Whitfield did to my daughter for 5 months. I have been trying to understand it, not to forgive it. I want to be honest about that. I am not here to perform forgiveness I do not have, but to understand it. Because Aubrey believed that understanding was the beginning of most things. She would have wanted me to try. She looked at the room. I cannot understand it. I have tried every day since November 14th and I cannot. My daughter went to school on a Thursday in November and she was lured to a narrow corridor. Or by someone she considered a friend. And she was killed there because someone had decided that what Aubrey had, her talent, her joy, the particular way she walked into a room and made it brighter without meaning to, belonged to someone else. And my daughter is gone. And I sit at the dinner table and her chair is empty. And I open the door of her room and her guitar is leaning against the wall exactly where she left it. And I call her name sometimes when I come home, before I remember. And then I remember. She lifted the photograph. It was Aubrey at the drama club's previous spring event. She was mid-laugh, head tilted, eyes bright, wearing the specific expression of someone caught in a moment of real joy they did not know was being documented. "This is my daughter," Diane Nolan said. "I want everyone in this room to see her, not the victim in a case file, her." She held the photograph for a long time. Then she sat down. Priya Rao spoke next. Aubrey's best friend since the 3rd grade, now 15, sat at the edge of her chair and read from a piece of paper in a voice that shook and held and shook again. "Aubrey texted me the day before she died," Priya said. "She sent me a voice message. She was singing badly. She always sang badly. She thought it was hilarious. She was singing a song from a movie we both loved, and she was completely off-key and laughing at herself in the middle of it. I have listened to that message every day since November 14th. I will probably listen to it every day for the rest of my life." She stopped. "I want Cora Whitfield to know that. I want her to know that Aubrey's voice is still here, that she didn't take that she didn't take everything." She folded her paper. She returned to her seat. Judge Elwood asked if the defendant wished to make a statement before sentencing. This was the procedural question that came at this point in every sentencing hearing. The defendant was not required to speak. Most chose not to, or chose to deliver a brief, attorney-advised statement of remorse that said what needed to be said for the record and nothing more. Patricia Vance had spent 2 hours the previous afternoon advising Cora not to speak. Not because there was nothing to say, there was a great deal to say, Vance believed, if Cora were willing to say it honestly, but because she knew her client. She had watched Cora for 6 months. She knew what Cora was going to do with an opportunity to speak, and she knew it was not going to help her. Cora stood up. "I have something to say," she said. Vance reached for her arm. Cora did not sit down. Judge Elwood looked at her steadily. "You may proceed, Ms. Whitfield." Cora looked at the courtroom the way she had always looked at it, taking inventory, assessing, preparing. She looked at the cameras first, found them as she always did in under 2 seconds. Then she looked at the jury box, empty now but still present in her gaze as an imagined audience. Then she looked at the bench. "I know what everyone in this room has decided about me," she said. "I've listened for 7 days to people describing me like I'm something they can't understand, like I'm a mystery that needs to be solved." She paused. "I'm not a mystery. I made a decision. I decided that something wasn't fair. I decided that if no one else was going to acknowledge that, I would do something about it. Aubrey had things she didn't earn. She had things that should have gone to people who worked harder, who wanted them more. I worked harder. I wanted it more. The world gave it to her anyway. The world has been doing that my entire life, and nobody in this room has the right to tell me I'm wrong for having a problem with it." The courtroom was not silent. It was the sound of a room attempting to process something in real time. Not gasps, but the collective intake of breath that happens when a statement passes the boundary of the expected and lands somewhere else entirely. Diane Nolan pressed her hand over her mouth. Priya Rao made a sound that was barely audible and completely devastating. Cora looked at the room, at all of it. She had their full attention and she knew it and she used it. The jury decided what they decided. The judge is going to sentence me to whatever she sentences me to. That's how this works. I understand that. She paused one final time. But I want to say, for the record, because everyone in this room keeps talking about truth and what's true. She looked directly at Judge Elwood. If I had the chance to make the same choice again, knowing everything I know now, knowing I'd be standing here, I'd do it again. The silence lasted 4 seconds. Then the room came apart. Voices, movement, the sharp sound of Diane Nolan's chair scraping back. A sound from Priya Rao that was not a word, the bailiff calling for order, reporters typing before the sentence was fully finished, a juror who had remained in the back of the room standing. G up as if the act required it. Several people in the gallery were on their feet. Patricia Vance had her face in her hands. Mara Whitfield in the 4th row looked at her younger sister with an expression that did not have a name. Judge Elwood struck her gavel, once, twice, 3 times. "Order," she said, her voice cut through the noise without being raised. "I will have order in this courtroom, now." The room quieted. It took longer than usual. Cora Whitfield sat back down. She looked, for the first time since the verdict, at something that was not composure and not calculation. She looked like a person who has said the thing they have been holding since November and has found in the saying of it, not relief exactly, but a specific kind of cold resolution. The expression of someone who has decided that if the world is going to take everything from them, they will at least deny it the performance of regret. That expression lasted until Judge Elwood began to speak. And then slowly it changed. Judge Sandra Elwood looked at Cora Whitfield for a long time before she said a single word. 22 years on the Georgia Superior Court bench, hundreds of defendants, thousands of hours in rooms where she had been asked to find the language that fit the truth of what was in front of her. She had been doing this work since Cora Whitfield was not yet born, and she had developed in that time the specific capacity to be in the presence of the worst things people do to each other and remain steady. Not unmoved, steady. She was steady now, and she was not unmoved. "Ms. Whitfield," she said. Her voice had changed register, not louder, slower, the specific pace of someone who is going to say something that matters and intends to say it completely. "I have been on this bench for 22 years. In that time I have sentenced defendants of many ages for many crimes. I have made, in every case I have handled, the distinction between acts that emerge from impulse and acts that emerge from calculation, between moments of terrible judgment that exceed a person's capacity to regulate, and decisions made deliberately, over time, with full awareness of what they mean. That distinction has guided everything I do in this courtroom. It is foundational to how I understand my role in the justice system." She paused. "I want to be clear about what that distinction looks like in this case before I say anything else, because I have heard your statement, and I intend to address it directly." The room was completely silent. "You said you made a decision. You said it was a decision born of the belief that Aubrey Nolan had things she did not deserve, that she had been given what should have gone to someone who worked harder, wanted it more. You said you did something about it because you decided the world was unfair and you were going to respond to that unfairness." She looked at Cora steadily. "And then you said that knowing everything, knowing where you are standing right now, knowing the verdict, knowing this room, you would make the same choice again." She let that land. "I want to tell you what I heard in that statement, not what you intended, what it actually said." Cora looked at the bench. "You have just told this court, and through this court, Aubrey Nolan's mother, her best friend, this community, and every person who will ever read the record of these proceedings, that what you did to Aubrey Nolan on November 14th was not a mistake, not an act of a developing mind that outran its own capacity for consequence-based reasoning, not the result of neurological immaturity. You told us it was a considered position, one you have reflected on for 5 months, one you maintain." She leaned forward slightly. "That statement is the most honest thing you have said in this courtroom. I want to acknowledge that. You have, finally, after 7 days of curated performance and careful selection of words, said something true. I want to address it with equal honesty." She opened the sentencing file. "I have considered with great care the science of adolescent brain development and what it tells us about culpability. I have read the defense's expert testimony. I have read the literature. I accept the neuroscience. I believe it, and I have applied it in every juvenile matter that has come before me, including 3 prior adult transfer cases." She looked up. "But the science of adolescent brain development at its foundation is a framework built on the possibility of change, on the understanding that the adolescent brain, precisely because it is still developing, has the capacity to become something different from what it is, to incorporate experience, to build empathy, to develop the moral architecture that matures with time. That is why the law treats juveniles differently, not because they are not responsible, because they are more capable of becoming something other than what they currently are. She looked at Cora. You have told this court in your own words, with full deliberateness and no ambiguity, that you do not intend to become something different from what you currently are. That given the opportunity, with everything you now know, with 5 months of these proceedings, with Diane Nolan's statement and Priya Rao's voice message and the testimony of your sister, and the 47 seconds of your own voice describing what you plan to do, you would make the same choice. She was very still. I cannot apply a developmental framework to a person who has explicitly, clearly, and on the record, rejected the premise of that framework. The law's protection of juvenile defendants is premised on the possibility of growth. You have told me there will be none. She paused for a long time. I have presided over 341 sentencing hearings in 22 years. I have heard statements of genuine remorse, and I have heard statements that performed remorse without meaning it. I have heard defendants say nothing and defendants say too much. I have never heard a defendant stand in this room and say what you said today. She opened the sentencing order. Aubrey Me Nolan was 14 years old, she said. Her voice was quiet and absolutely certain. She had a mother who sits in the first row of this gallery and cannot open her daughter's bedroom door. She had a best friend who listens every day to a voice message, so she doesn't forget the sound of a voice that is no longer in the world. She had a guitar leaning against a wall that no one has touched since November 14th. She had a story about a lighthouse keeper's daughter that strangers remembered. She had a future, she does not have it. She looked at Cora one final time. You took it from her because you believed her talent was a theft, because you believed that a drama teacher's casting decision constituted an injustice significant enough to warrant ending another person's life. And you stand here today and tell this court you were right, that you would do it again. She straightened. Cora Lane Whitfield, you are hereby sentenced to life in the Georgia Department of Corrections without the possibility of parole. You will be held in the juvenile facility until your 18th birthday, at which point you will be transferred to an adult correctional institution where you will serve the remainder of this sentence. She looked at Cora steadily. You told this court what you would do if given another chance. This sentence ensures you are not given one. The law allows this. The facts of this case require it. And what you said in this room today has removed every reason I might otherwise have had to reach for a different outcome. She struck the gavel. Once, the sound of it moved through the courtroom with a finality that everyone present felt in the chest. Not the sound of justice being satisfied. Justice is not satisfying, has never been satisfying, is not designed to be. The sound of a door closing, a sentence completed, a story reaching the place where stories of this kind reach. Not an ending, a stopping. Cora Whitfield was led from the courtroom by 2 court officers. She walked with the same even pace she had brought to every appearance in this building, every entrance and exit, across 6 months of proceedings. At the doorway to the holding corridor, she turned once and looked back at the room. The expression on her face was not what anyone expected. It was not the cold resolution of a person who has held their position. It was not the calculated performance of someone managing an audience. It was something smaller than both of those things. Something that looked, for just a moment, like the expression of a 14-year-old girl who has finally understood, in the specific finality of a gavel and a sentence without parole, that the story she had been running, the story in which she was the one who saw what others missed, who acted where others were passive, who corrected the injustices the world was too cowardly to address, was not the story the room had been watching. The room had been watching a different story entirely. For exactly 2 seconds, that understanding crossed her face. Then she walked through the door. It closed behind her with a sound that reverberated in the room long after it had stopped. In the first row, Diane Nolan sat still. She did not look at the door through which Cora had left. She looked at the photograph she was still holding, Aubrey mid-laugh, head tilted, eyes bright, and she looked at it for a long time in the quiet of the courtroom as it began to empty around her. Priya Rao sat beside her and did not speak. They sat together in the way of people who have been present at a thing that cannot be undone, and who do not yet know what comes after it, but who understand that whatever comes after it, they will face it in the same room. The Memorial Garden, outside the drama building received 2 new plants the following Saturday morning, planted by members of the drama club who had arranged to meet early before the building opened. They were rosemary plants, chosen by Diane Nolan because Aubrey had kept a pot of rosemary on her bedroom windowsill and had liked the smell of it. The club members planted them without ceremony. They stood around the garden for a while afterward and did not say much. Then they went inside to rehearse. Mr. Ellison had returned to the drama building 6 weeks after the sentencing. He had stood in the empty rehearsal room for a long time before sitting down. He had rearranged the chairs. He had written the spring production's title on the whiteboard. He had looked at the window and at the garden outside it, and at the chair in the second row where Cora used to sit and watch Aubrey deliver the lead scenes. He erased the title from the whiteboard. He wrote it again. He did not cancel the production. Some things you continue, not because they are easy, but because stopping means something has been taken that was not meant to be taken. The drama club performed in April. The lead role was played by a 7th grader named Me who had never auditioned before and who cried backstage the first night, before the curtain, from a combination of nerves and grief, and the specific weight of performing in a building where a girl had been killed because she was given a role. Me performed anyway. Aubrey would have, Priya Rao said afterward from her seat in the second row. She would have said that was the point. Bernard Solis, the digital forensic technician who had recovered the 47-second voice memo from a deleted file partition, submitted the case to the archive 2 weeks after the sentencing and did not look at the file name again. He had told a colleague once about the file name after and then had not spoken about it again. Some things you carry quietly. Detective Maya Akaffer closed the case file and moved to the next one, as she always did. She had been doing this for 15 years, and she understood that the work did not stop because a verdict had been reached, that the cases accumulated, and that the way you continued was to continue, to bring the same preparation and the same rule about assumptions to the next case that you had brought to this one. She drove past the school sometimes on her way home in the evenings. She did not slow down when she passed the drama building. She thought about the corridor sometimes, about the door with no exterior handle that could only be opened from inside, about the specific, operational intelligence of a 14-year-old who had understood that detail and used it, about the text message, "The back door is open, I propped it." She thought about what it meant that a 14-year-old had known to prop the door. She did not have a satisfying answer. She was not sure there was one. The case of the state of Georgia versus Cora Lane Whitfield was cited in subsequent legal proceedings across 6 states as an example of the specific evidentiary standard required for adult transfer of a juvenile defendant, and as an example of the specific circumstance, explicit, on-record rejection of rehabilitative capacity, under which life without parole could be imposed. Legal scholars argued about it. Child development experts argued about it. Criminal justice reformers argued about it. The debate would continue for years, and it would not resolve because the questions the case raised were not the kind that resolve. What it means to sentence a 14-year-old to life. What it means when a 14-year-old says she would do it again. What the justice system owes the living and the dead when those obligations point in different directions. These questions do not close when the gavel comes down. They stay open. They stay in the garden where the rosemary grows along the border. They stay in the voice message that Priya Rao listens to every day. They stay in the guitar leaning against the wall in a room that no one has entered since November 15th. Still there, still waiting, in the way that things wait when the person who was supposed to come back for them will not be coming back. Aubrey Nalan had been 14 years old. She had loved language because she believed it was the thing that made the truth sayable. She had believed that if you chose your words carefully enough, you could say exactly what was true. She had been learning to play the guitar badly and joyfully. She had written a story about a lighthouse keeper's daughter that strangers remembered. She had been the kind of friend who noticed when you had changed your hair before you finished walking through the door. She had deserved every day she was not given. And somewhere in a Georgia correctional facility, the girl who took those days would grow older in a room without windows that looked onto anything she had wanted, carrying the weight of a sentee. NCE that would not end, having said clearly, directly on the record, that she knew what she had done and would do it again. The court had heard her, and it had answered. Justice does not restore what is taken. It cannot fill the empty chair or quiet the habit of calling a name at the door. But it can stand in a room and say the true thing. It can name what happened and who is responsible and what the law requires when someone tells you, without ambiguity, who they intend to remain. It can close a door and let the garden grow. And hope, as courts have always hoped, as the people who do this work have always hoped, in the face of everything this work shows them about what human beings are capable of, that, on the other side of the closed door, in the long quiet of years without appeal, something eventually arrives that could not arrive before. Understanding, the kind that cannot be performed, the kind that comes on its own in the dark, when there is nothing left to manage and no audience left to perform for. Whether it comes for Cora Whitfield or not, no one in that courtroom could say. The court could only answer what she had said. And she had said, "I do it again." And the court had answered, "Then this is where you stay."